Hey everyone, welcome back to the channel. If you're new here, I share crazy HOA stories that'll make your blood boil and sometimes restore your faith in justice. Today's story is absolutely wild and honestly, I'm still processing everything that happened. This involves my emotional support dog, an HOA board that went completely off the rails, and a lawyer who literally threw in the towel because of how ridiculous things got. So grab some popcorn because this one's a doozy. Let me start from the beginning. My name's Sarah, and I live in Willow Creek Commons, a planned community in suburban Atlanta. When I moved here 3 years ago, it seemed perfect. Nice homes, well-maintained common areas, and the HOA fees weren't too crazy at $200 a month. The neighborhood was quiet, family-friendly, and exactly what I needed after going through a really tough divorce. Now, I should mention that I deal with severe anxiety and PTSD from my previous marriage. Without going into too much detail, let's just say my ex-husband made my life a living nightmare for 8 years. After the divorce, my therapist recommended I get an emotional support animal to help with my recovery. That's how I found Luna. Luna is a 3-year-old golden retriever, and she's absolutely perfect. She's well-trained, gentle, and has this amazing ability to sense when I'm having an anxiety attack. She'll rest her head on my lap or nudge me with her nose to bring me back to reality. Getting Luna was honestly one of the best decisions I ever made. She gave me back my confidence and helped me start living again instead of just surviving. When I first moved to Willow Creek Commons, I made sure to follow all the proper procedures. I had Luna registered as my emotional support animal with all the correct documentation from my licensed therapist. I submitted everything to the HOA office along with my move-in paperwork. The property manager, Mrs. Henderson, seemed nice enough and said everything looked good. She even commented on how beautiful Luna was when she saw her during my first week. For about 2 years, everything was smooth sailing. Luna and I would take our daily walks around the neighborhood. She was always on a leash, well-behaved, and honestly became something of a neighborhood favorite. Kids would ask to pet her, other dog owners would stop to chat, and several elderly residents mentioned how much they enjoyed seeing her during their morning walks. But then everything changed when the HOA board elections happened last spring. 3 new members were elected, and they immediately started making changes. The new board president was a guy named Richard Blackwood, a retired corporate lawyer who apparently had nothing better to do than micromanage everyone's lives. Within his first month, he'd already sent out violation notices for everything from mailbox colors to the height of people's grass. The first sign of trouble came in June when I received a letter from the HOA. It wasn't even properly addressed to me, just resident of 247 Maple Lane. The letter stated that they were conducting a comprehensive review of all pets in the community to ensure compliance with community standards. They requested that all pet owners provide vaccination records, registration information, and proof of homeowners insurance coverage for their animals. I thought this was a bit excessive, but I complied. I gathered all of Luna's paperwork, including her emotional support animal documentation, her vaccination records from our vet, and my insurance information showing that Luna was covered under my policy. I dropped everything off at the HOA office and didn't think much more about it. 2 weeks later, I got another letter. This one was different. It was on official HOA letterhead and addressed specifically to me. The letter stated that after reviewing my submission, the board had determined that emotional support animals were not permitted in Willow Creek Commons. They cited a community covenant that prohibited non-service animals and gave me 30 days to remove Luna from the premises or face daily fines of $50. I was absolutely stunned. I read that letter probably 10 times trying to make sense of it. How could they suddenly decide that emotional support animals weren't allowed when I'd been living there for 2 years, with full disclosure about Luna's status? I immediately called the HOA office to speak with Mrs. Henderson. "I'm sorry, Sarah," she said, and I could tell she was uncomfortable. The new Board is taking a much stricter interpretation of the community covenants. Mr. Blackwood says that emotional support animals don't have the same legal protections as service dogs, so they fall under the general pet restrictions. But Mrs. Henderson, I said, trying to keep my voice steady, I provided all this documentation when I moved in. You approved everything. Luna has been living here for 2 years without any problems. I know, and I'm really sorry about this, but my hands are tied. The board makes the decisions, and they've decided to enforce this rule moving forward. I hung up feeling like I'd been punched in the gut. Luna sensed my distress immediately and came over to rest her head on my knee. Just having her there helped calm me down enough to think clearly about what to do next. I spent the weekend researching housing laws and emotional support animals. What I found gave me hope. Under the Fair Housing Act, emotional support animals are protected in housing situations, even in communities with no pets. Policies. HOAs are required to make reasonable accommodations for people with disabilities, and my anxiety and PTSD definitely qualified. On Monday morning, I drafted a formal response to the HOA. I cited the Fair Housing Act, included additional documentation from my therapist explaining my need for Luna, and requested a reasonable accommodation hearing as outlined in federal law. I hand-delivered the letter to make sure they received it. The response came back within a week, and it was clear that Richard Blackwood had personally written it. The tone was condescending and dismissive. He claimed that the HOA had consulted with their attorney and determined that my request for accommodation was unreasonable because it would require them to violate their community covenants. He also suggested that if I needed an emotional support animal, perhaps I should consider moving to a different community that allowed pets. Reading that letter made my blood boil. The arrogance was unbelievable. But what really got to me was the implication that I should just pack up and move because they didn't want to follow federal law. I'd been through enough upheaval in my life. I wasn't about to let some power-hungry HOA president force me out of my home. I decided it was time to get professional help. I contacted a lawyer who specialized in housing discrimination cases. His name was David Martinez, and after reviewing my situation, he was confident we had a strong case. Sarah, he told me during our first meeting, what they're doing is textbook housing discrimination. The Fair Housing Act is crystal clear about emotional support animals. They can't just decide to ignore federal law because it's inconvenient for them. David sent a formal letter to the HOA on my behalf, explaining the legal requirements for reasonable accommodations and demanding that they immediately cease their harassment and allow Luna to remain in my home. The letter was professional but firm, and it outlined the potential consequences if they continued to violate federal law. You'd think that would be the end of it, right? A letter from a lawyer explaining federal law should have been enough to make them back down. But you'd be wrong. Richard Blackwood apparently saw this as a personal challenge. Instead of backing down, the HOA doubled down. They sent me another letter, stating that they were not intimidated by frivolous legal threats and that they were prepared to defend their community standards in court. They also informed me that since I had failed to remove Luna within the 30-day deadline, they were now imposing the daily $50 fines. The fines started showing up on my monthly HOA statement. $50 a day. Every day. Within a month, they tacked on over $1,500 in fines to my account. But here's where it gets really crazy. They didn't stop there. In August, I received a notice that the HOA was filing a lien against my property for the unpaid fines. They were also threatening to foreclose if I didn't pay the full amount plus legal fees within 60 days over an emotional support dog that was legally protected under federal law. David was incredulous when I showed him the foreclosure threat. I've been practicing housing law for 15 years, he said, and I've never seen an HOA be this blatantly defiant of federal law. They're either completely ignorant of the Fair Housing Act, or they think they can intimidate you into backing down. We filed a federal complaint with the Department of Housing and Urban development, and also prepared to file a lawsuit in federal court. But before we got to that point, something interesting happened. Other residents in Willow Creek Common started reaching out to me. It turns out that the new HOA board wasn't just targeting me. They'd been on a power trip since taking office, issuing violations for the most ridiculous things. One family got fined because their Halloween decorations were up for more than 2 weeks. Another resident was cited for having the wrong shade of white paint on their shutters. An elderly man received a violation for having a bird feeder in his backyard because it was deemed unsightly. People were fed up, and my situation became something of a rallying point. A group of residents started attending HOA board meetings to voice their complaints. The meetings, which used to have maybe 5 or 6 attendees, suddenly had 30 or 40 angry homeowners showing up. The first meeting I attended was absolutely surreal. Richard Blackwood sat at the head of the table like he was presiding over a corporate boardroom instead of a neighborhood HOA meeting. When it came time for resident comments, person after person stood up to complain about the board's increasingly authoritarian approach. When my turn came, I stood up and addressed the board directly. "Mr. Blackwood," I said, "what you're doing to me and my emotional support dog is illegal under federal law. The Fair Housing Act requires you to make reasonable accommodations for residents with disabilities. Refusing to do so isn't just wrong, it's a federal crime." Blackwood's face turned red, and he started lecturing me about community standards and property values. "Miss Thompson," he said, his voice dripping with condescension, "this community has rules for a reason. If we start making exceptions for every sob story, where does it end? Next thing you know, people will be claiming they need emotional support peacocks." The comment about sob story sent murmurs of disapproval through the crowd. Even residents who didn't have dogs seemed offended by his dismissive attitude. That's when Mrs. Patterson, an 80-year-old widow who'd lived in the community for over a decade, stood up and gave Blackwood the tongue lashing of his life. "Richard Blackwood," she said, her voice shaking with anger, "you should be ashamed of yourself. That young lady has been nothing but a model resident, and her dog is better behaved than most of the children in this neighborhood. What's next? Are you going to ban wheelchairs because they don't match the aesthetic?" The room erupted in applause, and Blackwood looked like he wanted to crawl under the table. But instead of backing down, he doubled down again. He announced that the board was hiring additional legal counsel to protect the community's interests, and that they would vigorously defend against any legal challenges. This is where the story takes another crazy turn. It turns out the HOA's existing lawyer, a guy named Robert Chen, had been getting increasingly uncomfortable with the board's approach to my case. David had been corresponding with him, and apparently, Chen had been trying to convince Blackwood to settle the matter. Quietly, Chen knew they were on the wrong side of federal law, and he'd been advising the board to approve my accommodation request from the beginning. But Blackwood had been ignoring his advice and pushing for a more aggressive approach. The relationship between Chen and the board had been deteriorating for weeks. The breaking point came in September. David had filed a motion in federal court for a preliminary injunction to stop the HOA from continuing to fine me while the case was pending. It was pretty standard procedure, and Chen knew the HOA was going to lose. He tried one more time to convince Blackwood to settle. According to what I heard later through the neighborhood grapevine, the conversation did not go well. Blackwood apparently accused Chen of being a weak lawyer who was afraid to fight. He questioned Chen's competence and suggested that maybe they needed a lawyer who wasn't intimidated by federal bureaucrats. That was the final straw. Chen submitted his resignation the next day, effective immediately. His resignation letter was reportedly 3 pages long and outlined all the ways the board was exposing the community to legal liability. He also apparently recommended that they immediately approve my accommodation request and settle the case before it went any further. But here's the kicker. Chen didn't just quietly resign. He sent copies of his resignation letter to every homeowner in the community. The letter detailed the board's refusal to follow his legal advice, their violation of federal law, and the potential financial consequences for the entire community if they lost the lawsuit. The letter caused an absolute uproar. Suddenly, every homeowner in Willow Creek Commons knew that the board was risking their property values and potentially exposing them to liability because they refused to let me keep my emotional support dog. People were furious. Emergency HOA meetings were called. Petitions were circulated calling for Blackwood's resignation. The local newspaper even picked up the story after someone leaked Chen's resignation letter to them. The headline read, HOA attorney quits over disability discrimination case. Meanwhile, David was having a field day in court. Without Chun to represent them, the HOA had to scramble to find new legal counsel. But what lawyer wants to take on a case where the previous attorney quit in protest and publicly stated that the client was violating federal law? They eventually found someone, but it was clear that their new lawyer was just going through the motions to collect a paycheck. During the preliminary injunction hearing, their attorney barely put up a fight. He seemed more interested in covering his own liability than defending the HOA's position. The judge granted our motion for a preliminary injunction, which meant the HOA had to stop imposing fines immediately and couldn't take any further action against Luna while the case was pending. But more importantly, the judge made some very pointed comments from the bench about the HOA's conduct. I have to say, the judge said, in my 20 years on the bench, I've rarely seen such a clear-cut violation of the Fair Housing Act. The defendant's position is not just legally indefensible, it's frankly embarrassing to the legal profession. That quote made it into the local newspaper article, and suddenly our little HOA drama was becoming a regional news story. Local TV stations started calling, wanting to interview me about the case. I decided to do one interview with the local NBC affiliate, hoping it might put additional pressure on the board to settle. The interview aired on a Thursday night, and by Friday morning, my phone was ringing nonstop with calls from reporters, disability rights advocates, and even a producer from a national morning show. The story was going viral on social media, with people sharing it as an example of HOA overreach and disability discrimination. But the real pressure was coming from within the community. Homeowners were organizing to recall Blackwood and the other board members who had supported his hardline approach. A group called Residents for Reasonable Representation formed and started collecting signatures for a special election. The recall effort gained momentum quickly. People were angry about the legal fees the community was racking up, the bad publicity, and the potential liability they faced if the board continued down this path. Property values were starting to suffer because buyers were hearing about the controversy and deciding to look elsewhere. By October, it was clear that Blackwood was fighting a losing battle on multiple fronts. The federal lawsuit was moving forward, the community was in open revolt, and the legal bills were mounting. The HOA's insurance company was even starting to ask questions about whether they would cover the costs of defending a discrimination case. That's when I got a call from David with some interesting news. The HOA's new attorney had reached out about settlement discussions. Apparently, Blackwood had finally been outvoted by the other board members who wanted to cut their losses before things got even worse. The settlement negotiations were brief because we held all the cards. The HOA agreed to immediately recognize Luna as my emotional support animal, remove all fines from my account, pay my legal fees, and implement new policies to ensure compliance with fair housing laws. They also agreed to make a donation to a local disability rights organization as part of the settlement. But the best part was the apology letter I received from the HOA. It was signed by all the board members except Blackwood, who had resigned and disgraced the week before. The letter acknowledged that their treatment of me had been inappropriate and illegal, and it committed the community to being more inclusive and respectful of residents with disabilities. The recall election went forward anyway, and the remaining board members who had supported Blackwood's approach were voted out by overwhelming margins. The new board immediately implemented the settlement agreement and actually went above and beyond in some areas. They created a community committee to review policies for potential discrimination issues and brought in a speaker to educate residents about disability rights. The story had one final twist that I didn't expect. About 2 months after the settlement, I was walking Luna through the neighborhood when Robert Chun, the lawyer who had quit, approached me. He was visiting a friend in the community and recognized me from the news coverage. "I want to apologize," he said. "I should have quit earlier when Blackwood first refused to follow the law. I kept hoping I could convince him to do the right thing, but I should have known better." I thanked him for eventually standing up to the board, and he told me something interesting. Apparently, word had gotten around the local legal community about the case, and Blackwood was having trouble finding any reputable lawyers willing to work with him on other matters. His reputation had taken a major hit. Chen also told me that my case had become something of a teaching example in fair housing law courses at the local law school. "Your story shows why lawyers need to be willing to walk away from clients who won't listen to legal advice," he said. "Sometimes doing the right thing means losing a client." Looking back on the whole experience, I'm amazed at how far things escalated. All of this drama, legal fees, and community upheaval could have been avoided if the board had simply followed federal law from the beginning. Instead, their arrogance and ignorance turned a simple accommodation request into a federal case that made national news. The irony is that Luna probably has more fans in the neighborhood now than she did before the whole controversy started. Kids still asked to pet her during our walks, but now adults stop to chat too. Many of them apologize for what the old board put us through, and several have mentioned that the whole experience taught them about disability rights issues they'd never considered before. The new HOA board has actually been great to work with. They've implemented sensible policies, they're responsive to resident concerns, and they seem to understand that their job is to serve the community, not rule over it like feudal lords. Property values have recovered, and the neighborhood feels more welcoming than it ever did before. As for me, the whole experience was traumatic, but it also showed me that I'm stronger than I thought. Standing up to bullies isn't easy, especially when they have institutional power behind them. But sometimes you have to fight for what's right, not just for yourself, but for everyone who might face similar discrimination in the future. Luna, of course, has no idea that she was at the center of a federal civil rights case. She just knows that she gets to stay in her home with her favorite human, and that's all that matters to her. She's still the same sweet, gentle dog who helps me manage my anxiety and PTSD. The only difference is that now she's also a civil rights pioneer. If you're dealing with housing discrimination related to an emotional support, animal, or any other disability issue, please know that you have legal rights and there are people who will help you enforce them. Don't let anyone intimidate you into giving up something you're legally entitled to have. And if you're on an HOA board or thinking about running for one, please remember that your job is to serve your community while following all applicable laws. A little humility and respect for residents' rights can prevent a lot of unnecessary drama and expense. Thanks for watching, and if you enjoyed this story, please like and subscribe for more HOA horror stories and happy endings. Let me know in the comments if you've ever dealt with an unreasonable HOA, and remember that sometimes standing up for yourself is the only way to create positive change. Until next time, keep fighting the good fight, and give your pets an extra hug from Luna and me.